Another day at Judiciary and Public Safety Committee. It's Thursday, April 8th, and we are starting on Senate File 970 today, which, as we talked about yesterday, is the vehicle bill on the provisions of our committee. Yesterday afternoon, we walked through the bill in the spreadsheet with Mr. Backus and Mr. Turner, explaining those, and we learned what was included in the bill. We also heard the public testimony pertaining to the bill yesterday. Yesterday evening, we heard testimony and had a very good discussion on Senator Limmer's A2 amendment dealing with the recent Supreme Court case, many of you know, State versus Khalil, and Senator Latz's A6 amendment, which makes further criminal sexual conduct modifications. Today, we plan to act on the bill with the goal of moving for a final vote at 2:45. To begin, we have the A1 amendment before us. The A1 needs to be moved and adopted to put the bill into shape the author wants, and we'll have discussion in committee action. Senator Limmer, there you are. Please move the A1 amendment. This would be an author's amendment.
Thank you, Mr. Chairman. The A1 amendment, as our members may recall, was the budget proposal that we considered and got a review on. I believe it was Thursday. No, yesterday. Oh my gosh, yesterday. And it's our starting point. It's our foundation. I'd like to put that into motion right now.
All right. Senator Limmer moves the A1 author's amendment. If we could put your microphones on and your cameras on. All those in favor of the A1 amendment indicate by saying aye.
Aye.
Aye. Aye.
All opposed? Motion passes. The bill is ready for further action. With that, I'll open it up to the committee for discussion. Any discussion?
Mr. Chairman?
Senator Latz.
Thank you. Mr. Chairman, I have a question for Senator Limmer. I have been informed that there's been a change to our judiciary target. Is that the case? And if so, by how much and for what purpose?
Mr.
Senator Limmer.
I'll have Mr. Turner explain the discussion that's been going on. It doesn't change our bottom line, but where the source of funding is. Mr. Turner, could you explain?
Thank you, Senator Latz. Mr. Turner?
Mr. Chairman, members, yes, there was concern about the fact that we had trunk highway funds in the bill. They've been in the bill for many years, and this has been a contentious issue with whoever chairs the Transportation Committee. And this year, the Senate has decided to swap out our trunk highway funds that go to the Bureau of Criminal Apprehension for DWI-related lab costs. It's $2,429,000 each year. We as the committee will be increasing its general fund target by $2,429,000 each year. It will be turning over the trunk highway fund money to the Transportation Committee dollar for dollar. And we have an amendment that does this. I don't know if it's been posted yet. But along with that, it's a dollar for dollar transfer or swap, trunk highway fund to general fund. We retain the rider in the bill that earmarks that money for DWI related costs at the BCA. And then there is a further paragraph, which I'll read verbatim in the amendment. Paragraph B, use of trunk highway funds, Department of Public Safety. Payment of expenses related to forensic science services and other activities of the Bureau of Criminal Apprehension do not further a highway purpose under Minnesota statute section 161.20, subdivision 3, and under Article 14, sections 5, 6, and 9 of the Minnesota Constitution. The Commissioner of Public Safety must not expend money from the Trunk Highway Fund for any purpose of the Bureau of Criminal Apprehension. And That, Mr. Chairman, is the issue and the amendment.
Mr. Chairman,
Thank you, Mr. Turner. Senator Limmer.
let me unpack this just a little bit. Senator Newman, the chairman of the Transportation Committee, happened to be reading the Constitution of our state a number of days or maybe a week ago. And in addition to the state statute that was referenced 161.20 sub 3, that there is a specific prohibition against using trunk highway funds. It's written that it will not be used for BCA purposes. And for over 30 years, we've been relying on funding from trunk highway fund sources to fund this type of expense for the BCA. And Senator Newman, I think he's probably more of a strict constitutionalist, has requested that we swap the trunk highway fund source for his general fund source. It's a dollar for dollar swap, but it would get everything in a line with not only previous statute, but also our Minnesota Constitution. I had a discussion with our leadership and Senator Rosen, and they have accepted and agreed upon this swap, and that's why we have it. There's no difference to the bottom line on the bill at all. It's just a sourcing of where that money comes from.
Thank you. Mr. Chairman?
Thank you, Senator Limmer. And just for members' note here, the 826 amendment has been posted, so you should be able to find that now on the website. Senator Latz.
Mr. Chairman, I agree with that in principle, and we'll support that amendment when it's offered. But if that's the chairman's intent right now, or otherwise, I have an amendment to offer.
Mr. Chair, while we're on the subject, I would like to introduce the 826, which covers exactly the discussion that we talked about with Senator Latz.
Certainly. Senator Limmer, is that your motion then to move the 826?
I move the 826.
All right. Well, if everybody would turn your cameras on, please, and your microphones. Unless there's further discussion, I should ask before. Any further discussion on the amendment? All right. Microphones on, cameras on. All those in favor of the 826 amendment, please indicate by saying aye.
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 All opposed? Motion passes. The 826 is adopted. We are on the A1 amendment as adopted. Senator Latz.
The A1 amendment as amended, Mr. Chairman?
As amended.
Thank you. Mr. Chairman, I have the 827 amendment.
All right. Senator Latz, the 827 amendment. And that one has been posted, correct, Senator Latz?
Yes, it has, Mr. Chairman.
All right. Senator Latz, to your amendment.
Thank you, Mr. Chairman. The 827 amendment is the criminal sexual conduct package of reforms reflecting the recommendations from the working group that we had extensive testimony on and discussion of last night. This is a sort of an all-in-one package. So it covers a little more territory than was in the A6 that we talked about last night. All of the substantive changes from the A6 are in there. But this A27 amendment also includes the language that was in the A2 amendment from last night that Senator Limmer had before the committee, which was the voluntary intoxication fix for the Khalil case. It was not in the A6 because it was already in the A2, so the A6 was drafted to the A2. Now we have it all in one place, so it's comprehensive in that sense. The A27 amendment also includes the repealer language that was inadvertently dropped from the A6 last night, but was described on the record. It also includes the what was prepared for last night is the 821 amendment, which is the funding mechanism in there. It includes the budget allocation or appropriation for the three pieces that were included in the working group recommendations. That is one new judgeship for the judicial branch in the amount of $482,000 in the first year and $449,000 in the second year. That's the judgeship and the supporting staff for a one judge unit. It includes funding for the Predatory Offender Statutory Framework Working Group that would be established by the substantive portion of the bill. And that funding is $131,000. And then it adjusts the institution's base budget to reflect the other costs in the substantive bill. So Mr. Turner can correct me if I misstated anything there, but I ask for the committee's favorable action today upon this amendment. I'm not going to repeat what I said last night, as we had, I thought, a very thorough and productive conversation, except I guess to reemphasize that this is 2 years of work product from a broad cross-section of stakeholders, including victim advocacy groups and victim survivors themselves. This will go a long way toward creating justice for current and future victims, and it's a well-balanced approach to this. I think we ought to be in a position to do this now rather than telling everyone involved in this aspect of the justice system that they will need to wait for another year. The time is now. There's an urgency now, and I ask the committee to support this amendment.
Thank you, Senator Latz. Appreciate the comments and the amendment. I have Senator Kiffmeyer, the hand raised.
I do, Mr. Chair, but if Senator Limmer had something to do first, as a courtesy to him, to go first, and if I could be next.
Certainly. Senator Limmer, and you're on mute right now.
Maybe in a few years I might learn this. I know it's a great entertainment for Senator Bigham, but Senator Latz, I just wanted to ask a quick question just on technicalities. Is this combined amendment identical to what we had discussed last night?
Senator Latz.
Yes, Mr. Chairman, there are no language changes in this amendment compared to what we discussed last night. There are the several additions that I just described, but in terms of the content that we went over last night, there are no language changes.
I have been told, Mr. Chairman and Senator Latz, that there might be a revisor instruction on section 39, as well as cross-references and maybe some language idiosyncrasies regarding the fifth degree on page 26 and 27. And I know that Mr. Backus is aware of these. I think there's also some cross-reference and adjudication terms. And I'd like to refer to Mr. Backus if he could explain some of these issues.
Thank you, Senator Limmer. Mr. Backus.
Mr. Chair and members, if I'm understanding you correctly, I spoke to one of your staff members earlier in the day. I think you're referring, I think if members can look at pages 26 and 27 of the A27 that's now before you. And Senator Limmer, are you referring to the addition of the adjudication concept in some of the provisions, but not all of them?
Yes.
Yeah, I think if maybe perhaps members look at, say, lines 26.28 and 26.29, you'll see that the adjudication concept is being added there, but it's not being added on lines 27.1 and 27.3. So I think there was a question at some point whether that needed to be changed as well.
Senator Limmer?
I'm trying to understand the reference on page 27. What line was that, Mr. Backus?
Mr. Chair, the last reference was to line 27.1 and 27.3. If you look there, there's reference in current law to previous convictions. The concept of adjudications are not being added there, while they are being added in line 26.28 and 26.29. I think that was the concern you wanted to raise.
Yes, and Senator Latz, would you agree that we need to make that reference of adjudications in lines 27.1 and 27.3 like they are in the previous page on 26.28 and 26.29?
Senator Latz?
I honestly don't know.
Yeah, Mr. Chairman, first of all, this apparent disparity was present in the A6 amendment last night as well. Mr. Backus and I had in fact identified that before, but this is the way the recommendation came in from the working group. So I don't have any specific knowledge as to why there is a difference there and whether the working group itself, overlooked that, those changes. I'm in a string here, a text string, since we don't have our testifiers from last night available on the Zoom hearing here to contribute. And so I'm looking to see if I can get a response from them right now. I don't have anything coming in to see if that was an intentional omission or not. So I think, Mr. Chairman, what I would ask is if I know that they're listening to this hearing and watching, so maybe we can defer that question for a moment while they're able to consult and maybe communicate back to me to see if there was some reason they did not include adjudication in clauses at lines 27.1 and clause C as well.
Wonderful.
And,
Senator Limmer?
thank you, Mr. Chair. Mr. Backus, were there any other cross references that we should be concerned with?
Mr. Backus?
Mr. Chair, members, I don't have, at some point, when I have time, I could try to review the amendment or the bill in its entirety just to see if there are any other questions. One I guess I saw was on line 27.5, the reference to paragraph A. That hasn't been changed in the bill. I would think that the reference they would want to change that to paragraph B, because current law's paragraph A is now paragraph B. Again, there might be other things that a closer reading of the bill or the amendment might find, but that's what I'm aware of now.
Thank you, Mr. Backus.
Mr. Chairman?
Senator Limmer, Senator Latz.
Thank you. It seems to me that at least that cross-reference may be more in the nature of a technical adjustment. And if we can't identify precisely what to do with that technical adjustment today, it's certainly something that we can correct down the road, unless Mr. Backus is confident right now that adjustment needs to be made, in which case we're happy to add it.
Mr. Backus?
Mr. Chair, it's up to the members. I believe it's something that would need to be changed. It certainly is something that could be done at a later date as well, after perhaps, maybe there's at some point we're able to put together more of a master list of questions, and then the advocates can speak to all of them at once. It's up to the committee.
Thank you, Mr. Backus. Senator Limmer, what route are you thinking you'd like to do? Would you like to start going through and making these technical changes, or
Well, I think,
bring together that list?
I suppose this has a little bit of, and I don't want to be too hypercritical. This kind of comes from, we thought we were pretty thorough last evening on this proposal. Sometimes it takes a little time to let it percolate down a little bit. I do want to move this bill forward. And this amendment is a collection of what we discussed last night. We know that the supporters are following the broadcast that we're talking about. And we'll have to continue to review this on some of these seemingly minor issues. But when it comes to substantive issues, that's really in our ballpark. And so right now, I don't know if these subjects are substantive or are they just, technical in nature. But we'll have to just watch and pay close attention. And as this bill continues to make its stops on these seemingly minor issues, I think we'll have to just proceed with it. Senator Latz, are you in agreement with that?
Senator Latz?
Yes, I am, Mr. Chair, and I am getting feedback now from some of the advocates that adding adjudication may be fine. But I think I'd prefer to be in a position to get a little more certain feedback from the group before we add it. So if I'm comfortable moving forward with that understanding.
All right.
Very good. Well, we're back to the 827 amendment right now. Any further discussion on the amendment? Senator Kiffmeyer?
Thank you, Mr. Chair. Appreciate this. The question that I have is picking up from the basic A2 amendment that we were talking about last night. And so now it's in the A27, and that's on line 7. It's section 15. In particular, the language 7.6 to 7.8. So Mr. Backus, if you could discuss a little bit, we had a discussion about mirroring parenthetical 1 and parenthetical 2. There was also the possibility of not having any list at all and just say any substance, striking and intoxicating, and just put any substance. And so could you just comment to that, Mr. Backus, if you're possible to do that, on explain a little bit more what the issues might be with mirroring, because I think parenthetical 1 and 2 are not quite exactly the same. One is administered to a person without the person's agreement, and the parenthetical 2 is the voluntary intoxicating substance situation. So they're not quite exactly the same, but could you just respond to some of the things I said? I'm not sure if you heard all of that.
Thank you, Senator Kiffmeyer. Mr. Backus?
Mr. Chair and members, yes, I did. Obviously the big substantive difference, of course, which is why we're all here on this issue, is the administered to that person without the person's agreement. But yeah, you're correct that, clause 2, as you can see, just doesn't exactly mirror clause 1. And that's kind of it's up to the members how closely you want those two to mirror each other. I did have a conversation with one of the prosecutors associated with the working group about how clause 1 would currently be interpreted, having nothing to do with the administered by the person's consent. And it appears to me that, you can mirror it if you want. One issue, for example, is would you want to have the reference to consent or consenting be similar? On line 7.7, it talks about rendering them incapable of consenting. On line 7.4 to 7.5, it talks about lacking the judgment to give a reasoned consent. For example, would you want to also have the second clause of unlettered clause of the second clause? In other words, where it says incapable of appreciating, understanding, or controlling the person's conduct, would you also want that to mirror clause 1? And then there's how the actual substances are referred to. Clause 2 refers to an intoxicating substance. We talked about that last night. Would you want to use that for clause 1, or would you want to use the language of clause 1, alcohol, narcotic, et cetera, for clause 2? Or would you want to use something different? I think it's really a policy choice how you would want to do that. I mean, we could work on that on the fly if you want. I know at some point, I think one of the members, perhaps she was interested in replacing intoxicating substance on line 7.8 with what is on line 7.3, alcohol or narcotic, et cetera. Again, it's up to you and the members how you want to have that read.
Thank you, Mr. Backus.
Mr. Chair.
Senator Kiffmeyer.
Yeah, thank you, Mr. Chair. I appreciate all of that. And I think with the conversation last night as well, including Senator Latz, I think the parenthetical 1 or 2 are enough different that I'm actually thinking to just strike "an" and put "any." So be that a person is under the influence of any intoxicating substance, and that simplicity might be the way to go in this particular situation. I'm certainly open, of course, but that would be the simplest change. And also their discussion last night of why they chose appreciating and understanding. Again, kind of the uniqueness of the parenthetical 2 situation as compared to the 1. So I think if we left it most like the task force did, and instead of saying "and," "any." And the other thing that one of the testifiers talked about, that sometimes it was more than 1, and sometimes it was you would be unable to determine maybe which one. So I think if you just say influence of any, I think it covers whatever is above in the parenthetical 1, and also any others kind of a situation that is up there. But I thought the simplest thing is to strike "and" and just put "any," and then in the future, the folks can comment, we can make other adjustments as well.
Thank you, Senator Kiffmeyer. Would you like to make that motion then for your verbal oral amendment?
Sure, Mr. Chair. I move on line 7.6 to strike the word "and," to delete "and" and replace it with "any."
Any discussion on the Kiffmeyer amendment?
Mr. Chairman?
Senator Latz.
My only question, actually, this would come up with the same question the way it's currently drafted, is whether it suggests it's got to be only one substance. If we put any substance or substances, then you'd account for multiple substances in the body as well, and you don't create a list which could be considered to be excluding anything else, unless council thinks that making it any substance would not limit it to only one, but could cover multiple substances by that very term.
Well, Mr. Chair, I'm perfectly fine with adding to my oral amendment, adding an S to substances. I think clarity is really important, but Mr. Backus may have an opinion.
Mr. Backus.
Mr. Chair, and I'm sorry, members, I don't recall the discussion about it being just more than one intoxicating substance. It
wasn't.
Yeah, I don't know. I guess I thought an intoxicating substance was fine. But if the committee, certainly if Senator Kiffmeyer wants to change it to any, or I'm sorry, I don't have a really strong opinion about that.
Senator Kiffmeyer.
Well, Mr. Chair, I think any intoxicating substances, I think, takes care of the fact that there may be one or more than one, and I think it makes it explicitly clear. So my amendment would be of any intoxicating substances.
Okay.
Mr. Chairman?
Senator Latz.
First, I'm going to note that there may be a little bit of a delay in the broadcast so that the working group members who are watching and texting back to me may be getting the question about 15 or 30 seconds after we mention it.
Thank you.
And so I will note that they're indicating to me, and I agree that they're fine with using the term any. I have one note that they still prefer mirroring the language. But I think since the working group itself didn't mirror the language, I just assume leave it the way it is at this time in terms of, not simply duplicating the language in paragraph 1. But I think if we put any intoxicating substances, substance being plural, I think that covers exactly what Senator Kiffmeyer is intending, and I think that covers the intent of the paragraph. So
Okay.
Mr. Chairman?
I'd be fine with that. And of course, we can certainly circle back somewhere down the road if the working group wants to adjust the nuances there at all. I mean, there was a reason why they left it the way it was, because they didn't want to get into a list and thereby have the appearance of excluding anything. So.
Senator Limmer.
Thank you, Mr. Chairman. Is the word intoxicating necessary? And the reason I ask that is a date rape drug, is that an intoxicating substance? And or ether or something that would put someone to sleep? Why would we want to limit it to just intoxicating substances?
That's a good question. Anybody willing to take that one? Mr. Backus?
Mr. Chair, I can't speak to why the working group settled on that term. I assume, I think I mentioned this yesterday, that it was an attempt to use a generic term to include, basically anything that could impair you. Senator Latz mentioned this yesterday. If you deleted intoxicating, I think it's going to be modified regardless of what's on the next line, which is it has to render them incapable of consenting, appreciating, understanding, et cetera. So I don't know how critical it is to keep intoxicating, but perhaps there are members of the working group who do feel strongly about that. I just don't know. Mr. Chair, sorry to chime in again, but I'm wondering if by using substances plural on line 7.6, if that somehow implies that it has to be more than one, which is the complete opposite of what the intent is. And I'm not sure how it's just a thought.
So, Mr. Chairman,
Senator Latz.
I agree with what Mr. Backus just said, and so does at least one of the representatives of the chief author in the House raised that question in text to me as well. So maybe the way to do this is to simply I would agree with Senator Kiffmeyer that we put in any instead of an. I guess I'm agnostic whether we keep intoxicating or delete intoxicating, because the real point is the effect, as Senator Limmer said last night, the real point is the effect of the substance, not the name of the substance or the term used to describe the substance. So maybe just any substance would take care of it, substance being singular, but then whatever's in the system takes care, is there. What matters is the effect. So I guess I would agree with both Senator Kiffmeyer and Senator Limmer. And putting those together would suggest that we delete an intoxicating and insert in its place the word any.
So Senator Kiffmeyer has a motion before us. Senator Kiffmeyer, would you like to modify your motion to incorporate what Senator Latz just said?
I think on the striking of and intoxicating and put in any, interestingly enough, yesterday when I was working on this, that is actually my first kind of a step. On the substance, and it was a testifier, not so much our discussion, who had an involvement in a medication she was taking, plus the alcohol and stuff. So one way we can get around that is substance / and then you put an S afterwards, which indicates that it could be one or more, if I'm correct. I'm not sure. That might be helpful. So it could be one or it could be plural. Mr. Backus, if I can ask you to help.
Mr. Chair and members, I wouldn't recommend that for a statute. If you wanted to achieve essentially the same result, I think you would say substance or substances.
That's fine too. Mr. Chair, I see Senator Pappas has her hand up and looking like she might have wanted to weigh in on this.
I'm sorry, Senator Pappas, I've had my little hand chart down. So yeah, if you want to speak to this, go ahead.
Thanks. I don't want to muddy the water, and I understand the effect, but I think there might have been a reason that intoxicating was put in there, because, you know, what if someone, you know, added food coloring and you're allergic to food coloring and there was an unintended effect? I don't know. We can't kind of think of every possibility, but I mean, I'm okay if you want to take it out now, but I think you need to kind of keep in mind that maybe that needs to go back in at some point if you hear more information.
Thank you, Senator Pappas. I do note though that, you know, in following in that paragraph, it also kind of modifies, you know, the language here where it says that you have to appreciate, understand the affects the appreciation, understanding, or control of a person's conduct. So something like food coloring, you know, may not have that same effect, but
Mr. Chair.
Senator Kiffmeyer.
Thank you, Mr. Chair. Well, those kinds of things can, and sometimes the interaction with other items, but I think Mr. Backus came with a better way. Any substance or substances to a degree. I'm just throwing that out as another version of this language. But I think, Mr. Chair, I so appreciate your patience with this. It is important, but we do have other opportunities to refine it further. But I think right now, in landing on it, my motion would be after of to strike and intoxicating, insert any, and after substance, add insert or substances.
All right. Oh, any further discussion on the Senator Kiffmeyer oral amendment? All right. With that, members, please turn your cameras on and your microphones. All those in favor of the Kiffmeyer amendment, please indicate by saying aye.
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 All opposed, same sign. Motion passes. We are back to the A27 amendment. Further discussion on the amendment.
Mr. Chair, I know we have a lot of things on our agenda yet. I was hoping to do a section, just a quick section by Mr. Backus to just, it's a big amendment. Senator Latz commented on it. So I'm willing to go with whatever the chair thinks we have time for right now, because we did do a thorough walkthrough last night, as Senator Latz said, subject to, of course, some of those edits that we've all agreed to that can happen going forward.
All right, let's turn to Senator Limmer. Senator Limmer, are you comfortable with our discussion last night and willing to move forward, or would you like Mr. Backus to briefly go over any issues within the bill or section by section? Oh, I'm sorry, your mute is on again.
Mr. Chairman, those are two different things you want me to comment on. I was in agreement with the substance of the discussion last night. I believe this combination of amendments that Senator Latz put together reflects the comments and the discussion we had last night. Outside of the minor references that we may need to have a little help on by members of the working group, I think this encapsulates the discussion that we had last night.
Thank you, Senator Limmer. Senator Kiffmeyer?
Well, I was looking at going through back. Is this repealer section 40 new? It wasn't there in the A6, was it?
Senator Latz.
Mr. Chairman, Senator Kiffmeyer, it was inadvertently dropped from the A6 last night in response to a question. I had mentioned last night that that was the case, and in response to Chairman Limmer's question, council identified the provisions that the repealer covers.
Senator Kiffmeyer.
Mr. Chair, I don't feel really comfortable about repealing section the repealer in section 40. I'm certainly comfortable with the rest of the bill, though.
Senator Kiffmeyer or Senator Latz, would you like to comment on that?
Well, Mr. Chairman, I'm not going to fall on my sword over the repealer, but I would note my understanding is that each of those sections has already been declared unconstitutional in terms of the conduct that they criminalize. So we're just cleaning up statutes to reflect that. But I'll stand corrected if someone has different information on that.
Senator Limmer.
References to unconstitutionality, Mr. Chairman. If the committee is uncomfortable with section 40, they should try and repeal it, or not repeal it, to remove it from the bill, delete it. I'll stand by whatever the committee decides.
Mr. Chair.
Senator Anderson.
Thank you, Mr. Chair. I have a little difficulty with my printer only printing an 8.5 by 11 sheet of paper, so I'm missing the 40 section 40 in my bill. So if someone could, or Mr. Backus could just give me an idea of what the section 40 is, I'd appreciate it.
Mr. Backus.
Mr. Chair, yes, it repeals 3 provisions in law. It repeals the sodomy crime, the fornication crime, and the adultery crime.
And Mr. Backus?
Senator Anderson, Mr. Backus.
Could you tell me how long that?
Anderson, Mr. Backus.
Could you tell me how long that language has been in statute? That we would be repealing it now?
Mr. Chair, members, I would have to look that up. I would assume they all go back somewhere, maybe to territorial days. They've been around a long time.
Senator Anderson, follow up.
Thank you, Mr. Chair. I'm concerned that, if it's been around for so long, what is it that we would want to take it out of the bill? And just not leave it in statute? Is there a problem?
Mr. Chairman?
Senator Latz.
From what I'm told, none of these 3 provisions are even charged anymore. They reflect standards of conduct from 200 years ago or 150 years ago, and have simply never been removed from the statutes. But as I say, it's not, a central concern here. And if it's got some members of the committee uncomfortable, then I'm fine deleting section 40.
Mr. Chair, I'd like to make that motion that we delete section 40, and just so we can move on.
Senator Kiffmeyer moves that we delete section 40 of the A27 amendment. Any discussion? Okay. Cameras on, microphones on, please, members. All those supporting the Senator Kiffmeyer amendment indicate by say aye.
Aye.
Aye. All opposed?
No. No.
All right. The Kiffmeyer motion passes to remove section 40. All right, we're back on the A27 amendment. Any further discussion on the A27? All right. Members, let's move to a vote then. Microphones on, cameras on. All those in favor of the A27 amendment, please indicate by saying aye.
Aye.
All opposed? Motion passes. The A27 is adopted into the underlined bill.
Right.
Oh, okay, very good. All right, so back to Senate File 970. Further discussion on 970
As amended?
as amended. Senator Pappas. Oh,
Um,
sorry, Senator Anderson, I'm sorry.
No, I just said as amended.
Okay. Senator Anderson, but you do have an amendment, is that correct?
I do have an amendment, the A30 amendment, Mr. Chair.
Okay,
Do you want me to go ahead with?
yeah, to your amendment.
Oh,
Senator
thank you,
Anderson.
Mr. Chair. Appreciate the opportunity to take the language of Senate File 1655 and we had some negative testimony the other day on this part of the bill, and people who are supporting the bill and people who are concerned about the bill got together and talked about it and wanted to have some different language proposed. And I looked it over and felt like that's what they want. If they could agree with it and go along with it, that I would propose the A30 amendment as it does. It basically does what we have. It just takes out some concerning language that they had regarding social determinants. And we're renaming it to we call it retention and domestic violence programs. And that's what we're after, is trying to reduce the domestic violence in our neighborhoods across the communities that we live in and across the state and across the nation for that matter. But it's the language that was concerning to some people. So we thought we could tweak it up, and we got both sides of it to agree on the language. And we're just basically coming forward with similar language and a report back to the Justice Program, Office of Justice Programs. So it's a good amendment that really doesn't deviate or doesn't take away from the purpose of trying to find out and trying to find the material and trying to find the evidence behind domestic violence in our communities and how we can get to some of the disparities that people are experiencing in their everyday life. So with that, I move the A30 amendment.
Thank you, Senator Anderson. Senator Anderson, do you have agreement amongst the stakeholders in this?
Yes, I do. I have talked with them, and they worked out the language, and so it's agreement on both sides of the issue.
Okay, and then just as I'm looking at this, it's kind of a scattered amendment, just changing the pieces in the bill. Mr. Backus, could you just briefly walk through a few of the main changes or substantive changes here to just so I'm clear? I know Senator Anderson, you did a good job, but I'm still a little bit foggy on this. Mr. Backus.
Mr. Chair and members, yeah. One thing it does is if you look towards 1.16 to 1.11 to 1.18, it adds a new some new information that the report would include, which is information, you see on line 1.12, information on whether the individuals were members of two-parent or single-parent homes. That's one thing. And then the other changes are kind of more related to the concerns that Ms. Brace articulated yesterday, relating to references to the social determinants of health and all that. So it's kind of like two concepts built into one: the additional information to be reported or information on, and then responding specifically to Mrs. Brace's concerns.
Thank you, Mr. Backus.
I'm sorry, Mr. Chairman, Mr. Backus, I guess it's kind of hard to do this online, but if you could, I have the bill pulled up. If you could refer, I know there were some things that were deleted. If you could tell me just the lines from the amendment. I can't see both the amendment and the bill at the same time.
Sure, Mr. Chair and members. do you want me to like just essentially read the amendment to you online, for example, online of the bill of the A1, page 9, line 10, the head note is changed to delete the reference to social determinants. And then page 9, line 15, after participants, insert voluntarily. And then,
Okay, thanks.
yeah.
That helps. That helps. That's good. Okay.
Thank you, Senator Pappas. Thank you, Mr.
Wait, he hasn't finished. Go ahead.
Mr. Chair, members on line 10, page 10, line 2, after staff, insert secure participant consent for assessment, comma. And then on page 10, line 28, basically the clause 1, if I remember correctly, the clause 1 is going to be the only thing reported. So page 10, line 28, delete the colon and insert the domestic violence recidivism rate of individuals who completed the program, including the age, race, and sex of those individuals before and after the pilot project began, which I'm having trouble toggling as well. I believe that was already the next line, but we just did it that way for the amendment purposes. But probably more importantly to you, page 10, or anyone, page 10, lines 29 to 33 are deleted, and then page 11, delete lines 1 to 6. So all of that is deleted.
Mr. Backes, I
Thank
was
you.
distracted a little bit with computer issues here. You are finished this time, right?
Mr. Chair, yeah, I don't think I've gotten 100% of everything, but those are the main things, yeah.
All right, thank you. Senator Pappas,
Yeah,
that
thank you.
satisfied? Wonderful. All right, we're on the A30 amendment. Any further discussion? Senator Limmer.
Mr. Chairman, I'm in favor of the amendment.
Thank you, Senator Limmer. With that, members, we'll vote on the A30 amendment. Cameras on, microphones on. All those in favor of the A30 amendment, please indicate by saying aye.
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 All opposed? Motion passes. We're back to Senate File 970 as amended. Further discussion on 970. Senator Pappas.
Thank you, Mr. Chairman. I have the A16 amendment.
16.
A16 amendment. Again, this is kind of awkward. But if you can click on the A16 amendment, it doesn't really amend internally. Like Senator Anderson's bill did, it adds another provision. And while you're pulling that up, I'm doing this for Senator Herr. He had asked me, first of all, to thank Senator Limmer and Latz for advocating with him to encourage the governor to launch the discrimination helpline under Department of Human Rights for those who've been discriminated against because of their Asian Pacific ethnicity. And what this bill does, it also funds an ability for an additional public or nonprofit organization to maintain a toll-free telephone line for people to report regarding incidents and crimes of bias, hate, and harassment related to COVID-19. And how this differs from the Department of Human Rights hotline is it will really provide more culturally sensitive outreach and offer language interpreters for languages spoken in Minnesota, including but not limited to Hmong, Karen, Bhutanese, Tibetan, Lao, Vietnamese, Cambodian, Chinese, Korean, Hindi, and Filipino dialects. And it also asks the commissioner to use a media-based campaign to educate the public on unjustifiable bias, hate, and harassment related to COVID-19 and the availability of the hotline. And it is a $600,000 appropriation. And the money is coming from the Department of Corrections, because I believe they have some flexibility in terms of the number of inmates, prisoners that they have. There's savings there in the budget. And so I'm taking a small amount of an additional savings to fund this bias hotline.
Thank you, Senator Pappas. Senator Limmer.
You're on mute.
Mr. Chairman, I understand where this amendment is going. We've had this discussion before in previous years. I had always looked at this as something that the Department of Human Rights seems like it's right down their alley. And that's why I've always kind of relied on human rights to provide that service. The other question I have is the $600,000 in the first year. And is it only for 1 year, or is it intended to continue? And then where is the money coming from? And I know that it seems like the Department of Corrections is the big slush fund that everybody's sucking money out of right now. And I suppose when you have that big of a savings, you become a ripe target for other needs. But I am concerned. I know there's a few other amendments that will dip into that or intend to do that. I'm just concerned that if we dip too deep, we could be causing a deficiency later on, and I would prefer not to go there. Eventually, someday in the near or distant future, the executive orders will be lifted and the courts will open, and then we'll have court cases putting people into our prison system. So I'm very concerned about not only the short term, but the long term on that. That's my concern about this event.
Mr. Chairman and Senator Limmer and Mr. Turner could help me if I need. I'm not sure if it's ongoing or not. I assume that it is. But I do know that you have mentioned yourself, Mr. Chairman, that you expect there to be some budget adjustments once you get into conference committee and negotiations. So I feel like there should be some flexibility in the budget to be able to fund this very worthwhile project. And let me just be clear, as I mentioned in my comments, that the Department of Human Rights does have a hotline, but it's just simply a phone call. You leave a message. It's not, and it's in English. It isn't really the kind of comprehensive thing that we're really, and they did the best they could in their limited budget, but it's not really the kind of thing we're looking for. We want something that's really going to reach out to the community with a trusted nonprofit, and also be able to do the many different languages that are necessary to really be responsive to the community.
Thank you.
Senator Bingham.
Senator Pappas. Senator Bingham.
Thank you, Mr. Chair. I just want to say that I speak in favor of Senator Pappas's amendment. This has just been an amazingly difficult, unprecedented time for Asian Americans and the hate that they are having to deal with, and the discrimination, and it's wrong. And we need to make sure that they have assistance to be able to get needs, to be able to have access to meet their needs, so that they have access to the Department of Human Rights. And so we need to continue to work on this. And I thank Senator Hurt and I thank Senator Pappas.
Mr. Chairman.
Senator Pappas.
Thank you, Mr. Chairman. I just wanted to mention a few facts that there is the nationally, the AAPI community has received 3,800 reports of hate incidences stemming back to March 2020. And that's probably only a fraction of the number of hate incidences that actually occur. And reported harm experienced by the AAPI community includes verbal harassment, shunning, physical assault, civil rights violations, including workplace discrimination, refusal of service, and being barred from transportation, and online harassment. And AAPI women are twice as likely to be targeted and have reported even more 2 to 3 times more incidences of hate directed at them. So unfortunately, it has been connected with COVID, with concerns about China's complicity in the virus, but most of these people are not even from China and certainly had nothing to do with that. So it's really been very unfair discrimination. And the US does have a history of discriminating against the Asian American community.
Senator Ingebrigtsen.
Thank you, Mr. Chair. And I guess I'm looking at sections 1.20 and 1.22. And I think maybe Senator Pappas, you just addressed the unjustifiable biases and hates and harassment that the Asian community is getting here in Minnesota. I guess I'm certainly not aware of that. And Senator Limmer makes a good point. We do have the Department of Human Rights, and I guess it would be, before I would vote for this, I would have to hear from them as to where the real problems are with regards to this that are ongoing.
Thank you, Senator Ingebrigtsen. Senator Latz.
Thank you, Mr. Chairman. And in response to Senator Ingebrigtsen, the conduct that is involved here that is really plaguing the Asian American community right now are not violations necessarily of the State Human Rights Act, which covers discrimination specifically in the context of employment or the provision of public accommodations and things like that. What we're seeing is on the street harassment, spitting, pushing, shoving, punching, elderly folks of Asian ethnicity and others, a conduct which is simply not covered by the Human Rights Act itself. And so while one may naturally think, yeah, the Human Rights Department should be dealing with this, it's not within their budget, it's not within their statutory purview, frankly. When they educate businesses in how to comply with the Human Rights Act requirements, how not to discriminate in hiring, firing, promotions, things like that, how to be not discriminate when they allow people or not allow people into their stores as retailers, and so on. I don't think it's averse to charge a different department with the responsibility for this. But I also suspect that there'd be no objection as long as the funding came along with it to ask the Department of Human Rights to do this instead of the Commissioner of Corrections. But it is a very real problem. And we are daily now across the nation seeing people are being very seriously assaulted because of their perceived connection to the origin of the COVID virus. And it may not be happening in communities where there aren't any Asian members or people living there, but where they are around, it is happening, and it's happening daily and frequently and in very serious ways. Now, there may be additional crimes being committed as well, such as assaults that are in connection with this, but it certainly is a public health issue, and it's certainly a terrible bias issue. And it's sort of the early stages, if you will, although it's been going on, since the coronavirus was determined to have originated in China, over a year ago now. But if we don't take strong public measures by all the ways in which people receive communication, now it is in effect a green light for this kind of conduct to continue and to escalate. And we've seen in other countries and other parts around the world where that can end up desensitizing members of the public to allowing that kind of conduct to continue and getting much worse. Senator Pappas read a resolution on the Senate floor today, illustrating the most extreme results of that kind of failure to act early when the public looked the other way. And that reflected in some ways, it resulted in the Holocaust in Germany in World War II. But we need to act strongly now in this way. I did have a question. I would like a clarification if this is one-time money or if it's ongoing appropriation. The amendment itself says the first year, so it might just be a one-time appropriation to establish this. But I guess that'd be helpful information to have as well for Mr. Turner.
Thank you. Mr. Turner.
Yes, Mr. Chairman, Senator Latz, and members. This is a one-time appropriation, and it comes from the Department of Corrections Institutions base budget, $600,000 in fiscal year 22.
Thank you, Mr. Turner.
Well,
Senator Latz.
Mr. Chairman, this certainly is an issue of public safety and which is appropriately within the purview of this committee as well. So I encourage members to vote in favor of this amendment.
All right. Any further discussion? Seeing none. Members, if you turn your cameras on and microphones on. Yeah. All those in favor of the, where is it here? The A16 amendment, please indicate by saying aye.
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 All opposed, no?
No.
No. Motion fails. We're back to the SF 90 or 970 as amendment. Further discussion on the bill.
Mr. Chairman.
Senator Pappas.
Yeah, I have the A13 amendment.
Senator Pappas moves the A13 amendment. Senator Pappas, your amendment.
Thank you, Mr. Chairman. We know that there has been ongoing criminal investigations into the January incursion, the insurrection at the U.S. Capitol, and it's revealed that dozens of rioters who were current or former law enforcement officials or military officials with ties to or were members of white supremacist groups. Frankly, we don't need individuals with this mindset tasked with keeping all Minnesotans safe. I believe that a licensed peace officer's affiliation with support or advocacy for white supremacist groups' causes or ideologies is patently inconsistent with their duty to protect and serve each and every Minnesotan with equal vigor. So what this amendment would do is tell the Peace Officer Standards and Training Board that they must revise the Peace Officer Standards of Conduct that the board is mandated to publish and update to prohibit peace officers from affiliating with, supporting, or advocating for white supremacist groups, causes, or ideologies, or participation in or active promotion of an international or domestic extremist group that the FBI has determined supports or encourages illegal violent conduct. And Mr. Chairman, I would actually like a roll call vote on this amendment.
Roll call has been requested. I believe I need.
Mr. Chairman, I request that the roll call be recorded in the journal.
Okay. Senator Limmer.
Mr. Chairman, Senator Latz had a request that the roll call be recorded in the journal, and you will have to ask for 3 hands to proceed with that motion.
I will do that. Can we see 3 hands for the Limmer motion or the Latz motion? Thank you. Okay, Senator Limmer.
Mr. Chairman, could you announce the results of that for the record, please?
There were 4 hands I saw.
So the roll
If
call.
I did my math right, 4 hands.
Yes, Mr. Turner. So the roll call will be recorded in the journal.
Roll call will be recorded in the journal.
Thank you, Mr. Chairman.
Senator Limmer.
Thank you, Mr. Chairman. Senator Pappas, as I was reviewing this, I have to say up front that I don't think there's anyone that is in support of white supremacy, at least on this committee, and probably not even in the entire legislature. white supremacy is a stain on the United States and its history. However, preceding that history was the Constitution. And there are a lot of times when I see associations of people, citizens gathering, and their right to associate, the right to freedom of speech, the right to religious practice. And I'm uncomfortable with the way the amendment is formatted because I see it as unconstitutional. The words on 1.8 prohibit peace officers from affiliating. That's the association that I was talking about. Promote white supremacy and the idea that white people are superior to blacks. The idea that white people are superior to blacks and indigenous and people of color, that idea is repugnant to me. But it also recognizes a religious practice in line 116 and inflammatory speech. I'm just concerned that by what I can tell, the Constitution would allow individuals to have that freedom, whether we agree with it or not. They have the right to associate, have a religious practice, and enjoy a freedom of speech of their own design. And so I'm very concerned about putting this in the bill. I agree with you about the repugnancy of white supremacy. And so, and in addition, if I can remind everyone, this is a budget bill, and this amendment does not have a budget element in it.
Mr. Chairman, I just wanted to make a few comments in response. I think that there probably, thank you, Mr. Chairman. And Senator Limmer, I think you, my goal is really to do something that's very similar to the Federal Hatch Act, which, as you know, does not allow federal employees, which my husband is one, are not allowed to actively participate actually in a political party. And it doesn't mean you cannot vote, certainly as how you wish to do that. These police officers are representing a certain standard, and we hold them to a high standard in our communities of behavior. And so I do think that it is similar to what we require of all our federal employees, is that they not be outwardly politically involved. So where I think that we probably, my interest is mostly in affiliating with, certainly active promotion of a group that encourages illegal violent conduct is something that we should not allow. But I think that supporting or advocating for, certainly supporting, may cross into that line you're talking about in terms of the Constitution. But affiliation, we had groups in Washington that were clearly, were affiliated. They weren't just expressing an opinion that may be distasteful to some of us, but they were actually affiliated with a group and participating in actions that were violent or illegal. So I would certainly accept deleting the language, supporting or advocating, but leaving affiliating with white supremacist groups, causes, or ideologies. And then again, your other comment you made is we're talking about a definition really of white supremacy groups, but it still is controlled by my language, which just limits it to participating in or affiliating with.
Thank you, Senator Pappas. Any further comments?
And I'll make that motion myself, Mr. Chairman, and that would be on my amendment, the A13 amendment, to delete on line 1.9 supporting or advocating for. And then we limit it to affiliating with white supremacist groups. And I can just incorporate that, perhaps, Mr. Chairman, into my A13 amendment.
So this would be an amendment to your A13 amendment.
I believe I'm allowed to just incorporate that change. It's up to you, Mr. Chairman.
Okay. Any comments, Senator Limmer?
So are we voting on the amendment, Mr. Chair, or has Senator Pappas adopted a change to her amendment?
Senator Pappas.
I'm proposing a change to my amendment.
Okay.
I'd like to just incorporate the change that on line 1.9 deletes supporting or advocating for.
Sure.
So are we only, Mr. Chair, are we only voting for the change, or are we voting for the bill as incorporated by Senator Pappas?
Senator Limmer, we'll kick this over to Senator Backus. I believe we're voting on the
Mr. Backus
amendment with the incorporation.
Mr. Chair, members, I think it's up to the chair. You know, I think Senator Pappas, suggested that she simply incorporate this change without a vote, which, is something we often do. If you want to vote on the specific change, I guess you could do that as well. I would point out that on line 1.9, you'd want to include the first comma. So you delete comma, supporting, comma, or advocating for. So if Senator Pappas wants to incorporate that into her amendment. And then if Mr. Chair, if you're comfortable with that, then at some point you could just vote on the amendment as amended, as Senator Pappas mentioned.
Thank you, Mr. Backus. We'll do that then. We'll just incorporate your suggestion,
Thank you.
Senator Pappas. Any further discussion?
Mr. Chair,
And I want to just say quickly that for some reason my hand feature isn't working. So if you'll just wave at me on the screen, if you want to talk, that's going to work the best. So I got a couple here. Senator Limmer.
Mr. Chair, although the alteration to the A13 amendment is now present, I still believe, especially in paragraph B, that there's still references to people that might be restricted due to their religious or their speech. And I still think it violates constitutional principle. So I'm sorry, Senator Pappas, I can't support your amendment.
Mr. Chairman, early on in my legislative career, I was taught that whatever the legislature does is constitutional, and then we let the courts make the final determination. So I'm going to proceed with my amendment.
Mr. Chair.
I missed that day.
Senator Latson, you were waving earlier.
I was just being friendly, Mr. Chairman.
All right. With that,
No.
Mr. Chair.
I do think Ingebrigtsen
Senator
has,
Ingebrigtsen.
yeah.
Real simple, real quick, Senator Pappas. Is this a real problem in Minnesota with Minnesota law enforcement?
Mr. Chairman, I don't have that information to know if it's a real problem, but I think it's important to be proactive. And I'm sure that the Peace Officer Standards and Training Board I have not consulted with them, I'll be honest with you, but I'm sure that most communities in our state would not approve of peace officers who have this kind of ideology.
Thank you, Senator Pappas.
You're correct. Thank you.
Thank you, Senator Ingebrigtsen.
No, I am waving, Mr. Chairman.
Senator Latz.
Thank you. Whether we know or not if it's a specific problem in Minnesota, we do know that the problem exists and that it is in law enforcement circles. We know that it's in military circles because there is some data nationwide on that. And so I don't know that we can think of Minnesota as an isolated bastion of the absence of these kinds of affiliations. We do know some of these groups, these white supremacist groups, are active and present in Minnesota. So I think this would be a really important statement to make. I don't think that law enforcement has the same level of unfettered First Amendment rights that others do, particularly because the nature of their job is to enforce the law equally and without any preference or bias for or against different ethnic groups, or certainly not in favor of whites over people of color. And this is an important message that would affect the level of trust and confidence that our communities would have in their law enforcement to enforce the laws equally and fairly. So I think this is it's a valid issue, and this is a really important step that we can take to give the Post Board the tools to make sure that our law enforcement ranks are sanitized, if it were to come to that, of these levels of bias and affiliation. Thank you, Mr. Chairman.
Thank you, Senator Latz. With that, members, we'll move to a vote on the A13 amendment. Please turn your microphones on. There has been a roll call requested. Sage Petrusa, would you mind taking the roll?
Will do. Senator Limmer,
No.
Senator Anderson,
No.
Senator Bigham,
Yes.
Senator Ingebrigtsen,
No.
Senator Johnson,
No.
Senator Kiffmeyer,
No, this is not the Hatch Act.
Senator Latz,
Yes.
Senator Matthews,
No.
Senator Pappas.
Yes.
There being 6 yeses and 3 nos.
Thank you, Ms. Petrusa. The motion fails.
Mr. Chair, did she say 3 yeses and 3 nos? I'm sorry, I thought she
No, it's
6 no's.
6 no's,
Yeah.
3
Right.
yeses.
Okay. Just want to make that clear.
All right, Senator Pappas.
Thank you, Mr. Chairman. It's my third and last amendment. It's the A15 amendment.
Senator Pappas moves the A15 amendment. Senator Pappas, to your amendment.
Thank you, Mr. Chairman. We actually had a precursor to this amendment last night when Senator Mary Kunish spoke. So I don't feel like I have to say a whole lot. It is funding the office for the funding on the Missing and Murdered Indigenous Relatives Office. It establishes an office dedicated to preventing and ending the targeting of Indigenous women, children, families, and it provides $500,000 a year for the office. As we heard from testifiers last night, the reports from the working group on missing and murdered Indigenous relatives, if we truly want to combat this problem, we must build on the work from the group, and establishing the office will do so. And Mr. Chairman, I'll kind of leave it at that and hear what Senator Limmer has to say about this.
Thank you, Senator Pappas. Senator Limmer.
Mr. Chairman, Senator Pappas, on line 1.6, you talk of $500,000 each year to establish and maintain an office. Does this have tails as well? Is this, or perhaps I should ask Mr. Turner. Mr. Turner, in the description of the funding, is this an ongoing appropriation?
Mr. Turner.
Mr. Chairman, members, yes, it's $500,000 each year of the biennium and then ongoing in the tails.
Thank you, Mr. Turner.
Senator Pappas, where is the source of this funding?
Again, it's coming from the deep well of the corrections savings.
All right.
And it also is certainly dependent on when you get a higher target. Mr. Chairman, many times we authorize reports to be done and then they come back and then we don't do anything. And I really think it's really important that this just doesn't sit on a shelf and that the momentum for this work continue. And in order to do that, you've got to have somebody who's doing it. And that's what the work of this office would do. Look at what is the source? Why are Native American women murdered at such a higher rate than their percentage in the population? I believe Senator Kunish said last night about 8%. their population is 1%, and yet they're 8% of the murders. And it's really important that we get to the bottom of this. Some of it probably has to do with sex trafficking. We don't know.
Mr. Chairman,
Senator Limmer.
I understand the concern. That's why we started the task force in the first place. As we're beginning to get a greater depth of what's been going on, it was my hope that law enforcement would start furthering an inquiry into what's going on in their local jurisdictions, as well as perhaps BCA could also follow the conclusion of the task force report. I wasn't quite ready to create another bureaucracy extending from it, nor was I ever told about doing that when the task force was first created. And so we've got other ways to do this. And one way is to direct VSETs to go directly into this program with law enforcement and pursue. That's another option that we could do. Rather than creating a bureaucracy, we could actually get boots on the ground and start digging into this. So I'm not really in favor of creating another bureaucracy. I'm also wondering if we couldn't task perhaps some of our councils, minority councils, to begin to do some of this work as well. So I think there may be existing elements in state government that might be able to pursue this, and maybe with a little bit more law enforcement authority to pursue. And I'm also very concerned about the Department of Corrections budget. If we keep tapping into it, we're going to have a serious problem in the near future. I know that I have to make an apology to Commissioner Schnell, who tried to get a hold of me shortly before this committee was being conducted. And I did not have the opportunity to pick up the phone or to call him back. But I could only imagine after our discussion yesterday that he's very concerned about his existing budget. So at this time, I will keep an open ear on this as we progress over to a conference committee. But right now, I would prefer not accepting this amendment.
Mr. Chairman and Senator Limmer, I know that you were a supporter of the task force in the past, and I actually don't see this as creating a huge bureaucracy. It's just an office with the Commissioner of Public Safety and a couple people to kind of coordinate the work with communities and tribal nations and other partners. So often the most efficient way to do something is to have some center, some center point where activities are being coordinated. Otherwise, it can be, you don't know what everyone else is doing on the same issues, and you're not sharing information that needs to be shared. So I would hope that you would keep an open mind about doing this as in the next 5 or 6 weeks, and that we might be able to come up with something. I don't know that it was ever planned ahead of time to create an office. I'm sure that came out of the work that the task force did. And I've noticed that with the sex trafficking work, it was also very helpful to have in the Office of Justice Programs a kind of a center where everyone got together on the task force and could share information. And they were also staffed minimally, but they were staffed. And we've really been able to get on top of the sex trafficking issue in our state. We've passed wonderful laws. We've funded victims services. And I know this would also be a great addition. But I have not been spending that much from that budget since you didn't pass my amendment. So I just wanted to say I've not been a big spender here, not taking money from corrections, but I will withdraw the amendment at this time. Thank you.
Thank you, Senator Pappas. Senator Pappas withdraws the A15 amendment. Senator Bingham.
Thank you, Mr. Chair. I have the A12 amendment that I would like to offer.
Senator Bingham offers the A12 amendment. Senator Bingham, to your amendment.
Mr. Chair, this is, and I'm going to need Mr. Backus to help clarify too, but Mr. Chair and members, this is the doxing bill that prohibits the doxing of law enforcement's address, pictures, directions, And when we passed it unanimously, but I don't know, a little more than a month ago, Hennepin County came to me and said, hey, heads up, might be a constitutional First Amendment challenge to how and where we had it linked to in statute. So of course I went to Mr. Backus, and he helped me, and he suggested that maybe we put it to the harassment statute. So Mr. Backus, if I would appreciate confirming or correcting.
Thank you, Senator Bingham. Mr. Backus.
Mr. Chair and members, yeah, what happened, is the Hennepin County Attorney's Office reached out to Senator Bingham, and they made a good point that the bill as originally drafted and as passed this committee was susceptible to a First Amendment challenge. And of course, that's not the intent. So the solution for that was, if you look at the A12 and you look at, say, lines 1.15 to 1.16, language is added that the action has to be with the intent to injure, harass, or intimidate the law enforcement official or family. And yes, that mental state essentially comes from the harassment stalking law. So it's just an effort to add another step in order to violate the crime and insulate it from a First Amendment attack.
Yeah. So,
thank you, Mr. Backus. Senator Bingham.
So, Mr. Chair, I was just hoping we could include that in the omnibus bill. That was it.
Thank you, Senator Bingham. Senator Limmer.
Thank you, Mr. Chairman. I do know that this is a policy only provision. They have a budget consideration. The other question that I did have is, I know that the newspaper industry, as well as realtors, are concerned about the issue of photographing homes. And I don't know if they've really ferreted it out in detail, at least the realtors, because they take photos of homes all the time. But we do, as you mentioned, we do have this subject that had already passed out of our committee.
Yeah.
You had just told me that there was concern on the constitutional grounds.
Yeah.
Was that your bill or was that someone else's bill? I can't recall.
Mr. Chair, it was my bill.
Yeah. Would it be possible to move your changes into your bill that's already resting on the floor?
Mr. Chair, of course that's possible. I was just hoping to include it here. You know, I like to make sure that I have my provisions in play in many different areas so that hopefully one time it gets across the finish line. And so, and I think it's an important policy, and for the realtors and stuff like that, that's why we have the intent. And actually what this does makes that should go away, because this is now tied to the harassment clause, not the original one. So this one would alleviate their concerns even more.
And Senator Limmer.
Mr. Chair, I'm really trying to keep our focus on budget on this bill. I've always said it every time we've made a presentation on this bill, and for many years we've tried to stay focused on it. Right now I'm hesitant to accept it. And the reason is that there's already a similar subject bill proceeding. It is subject to amendment. And I would not like to start the practice of adding policy-only provisions onto a budget bill in the Senate.
Thank you, Senator Limmer. Senator Latz.
Thank you, Mr. Chairman. Could we add an appropriation for $1 to print the paper that's necessary to disseminate this information, and that'll fit within your bill?
I think I would still oppose it, Senator Latz. Good try.
Certainly, Mr. Chairman, the concerns of realtors and others would be completely eliminated with the way this is now drafted, unless they were taking pictures of houses rather than for the purpose of marketing the houses. but for the purpose of creating an imminent and serious threat to an official's safety, and knowing or reasonably should know that that threat is imminent. So unless you got some real outliers out there in the realtor community, that community shouldn't have to worry about this at all the way it's written.
Yeah.
Senator Limmer, did you have a comment? Senator Bingham.
Yeah, and just, Mr. Chair, I mean, it's a good provision. It's very strongly bipartisan, and I think it's something that we should advance. And if it's in conference committee, then you know what, it's your conference committee, sir. So if it doesn't survive it, it doesn't survive it. And then you're going to turn to me on the floor and say, well, Senator Bingham, go talk to Senator Gazelka about getting your bill off of general order. So, I mean, I just think having it in multiple places is good.
Thank you, Senator Bingham. Any further comments? All right, members, we will move to a vote on the A12 amendment. Cameras on, microphones on. All those in favor of the A12 amendment indicate by saying aye.
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 All opposed?
Oh,
No. Motion fails. The
And then-
A12 amendment does not pass.
Boo. Mr. Chair,
Senator Bingham.
I have the A35 amendment.
All right, Senator Bingham moves the A35 amendment.
Yeah. So,
Senator Bingham, to your amendment.
Thank you, and I'll be very brief. Mr. Chair, simply put, yesterday I asked Commissioner Harrington about the use of force law that was passed last year and the concerns in the legal world and law enforcement about its constitutionality, and that there's a lot of concerns about training. It was a well-intentioned law that was not probably written well. And so I'm on a border town, Mr. Chair, and I know you are too, Mr. Chair. And I have local law enforcement, both municipality and county sheriffs that are on multi-jurisdictional task force, whether that's for gangs, whether that's for trafficking, and those officers that are not in Minnesota are not wanting to come over here to help to participate in the investigation and stuff because they're afraid about getting charged. And so the other, concerned, not afraid. And the other problem is that that's going to start impacting a lot of the investigations that are going on. And there's also been incidences, and it's been in the news too, but like high-speed chases that are going between Wisconsin and Minnesota, and getting stopped right at the border. Law enforcement will stop right at the border because they don't want to come across, because again, they're concerned about the law. So the other side of this is that I believe everybody wants a constitutional law, a law that people, law enforcement can get trained on so that there is justice if there is something that occurs, but also for transparency. We also don't want people being trained currently on a law that may not be constitutional and just add the confusion. So I have been working lately with trying to come up with some language, and it's just with the time constraint today, it's just not able to. And then I also think, Mr. Chair, we're not hearing testimony today. And I think fixing this at this moment right now without testimony, we're in a conference committee, at least those that I have been on, there's been testimony. Plus you have the House. What amendment the 835 amendment does is simply delays the implementation of the use of force until September 1st. So I believe that that gives this committee I believe that this gives the conference committee time to work on this, because I can't just not do anything, Mr. Chair. And I think that you'd probably feel the same way being from the other side of the state, but the Dakotas. Our law enforcement agencies, but our communities also need this. So, just to clarify that both Attorney General Ellison's office and Harrington have expressed the concern on the constitutionality of one of the tests in the current law that about an officer must articulate the need for deadly force, and that could be self-incriminating. And so that might be the reason why we are having to clear this up. There is one other point, and then I'll be done, I promise. In the current law, there also talks about the use of force must be, or the great bodily harm must be to the law enforcement or to someone else. But it doesn't deal with what if there is being harm done to oneself, like a mental health issue, like a suicidal issue. So that has to be, and whether an officer would intervene in that. So I think there's just some broader discussions that need to happen. But what I'm hoping is we can have this into conference, so we can have the who's ever on that committee can have the conversation to help with this issue.
Thank you, Senator Begum. I appreciate the concern, and of course, I've got that also in my communities. But Senator Limmer, would you like to talk about your budget bill and how this policy provision fits in that?
Well,
Objection, that's leading the witness.
Senator Limmer.
you've been hanging around attorneys a little too long, Senator Begum. I want to thank you for bringing this issue up. Generally, I support the provision, but I don't think it's necessary to put in this bill. And the reason why is we've already voted on this in Senator Weber's bill, the SAFE Act, or the SAFE bill, and we included the 6-month delay in training, which is already passed on the Senate floor. And so, again, it's a non-budget bill again. And since we haven't, since there's no funding in it, it's policy only. We've already voted it on the Senate floor, so it's already the established position of the Senate. And so I think we've already been there. And so I don't find it necessary to reapply it in this bill.
Thank you, Senator Limmer. Senator Begum.
Again, I also think it's important that we have this in as many places as possible, because I do believe it's a timely issue. It's an issue that needs to get fixed. And I just don't feel like just because it's, I mean, we do that a lot of times where multiple similar provisions are done throughout the legislative process. So I certainly don't think it's harmful. I don't think it's harmful. And I think that it's worth going into conference committee with this to have the discussion. That's where I think is important for your position going into conference committee. And so that is, I just think then you can have people testify on it, all the stakeholders on it too, to hear everybody out. But I really feel like something needs to be fixed. And if we can't have language right now to fix it, then I think we should look at the delay so that we can give people opportunity to work on it.
Thank you, Senator Begum. Any further comment on the 835 amendment? Okay, so I will say we're at the 245 mark presently. What I'd like to do here is we'll take the vote on this after your comment, Senator Latz. But then does anybody want to offer any more amendments after the A35? If we do, we'll be back at 5:30 this evening to go through those and finish up those amendments. So there are, I'm seeing some head nods, so there will be several amendments following.
Well, I don't know about several, Mr. Chair, but I have two more I wanted to talk about.
Okay. Then, okay, so we will be coming back at 5:30. So we're going to be using the same link at that point. So with that, let's go back to the A35 and finish up our discussion there. Senator Latz.
Mr. Chairman, I would just add, I think there's some doubt about whether or not the SAFE Act is going to get across the finish line this year. So I don't think we can count on that vehicle to implement a delay. I happen to support a delay. I would like to see a repair to the use of force language to make sure that it is constitutional. Although I think it's also critical that we have valuable adjustments made in the use of force guidelines for law enforcement as well. So I want to have it both ways. I want to have one that's effective in circumscribing the use of force by police officers so that they aren't using it where it's inappropriate. I want it to be constitutional, and I want there to be a time for appropriate training, and I don't want to have them trained in an unconstitutional method. So I think we've got to dual track this package. But perhaps the delay will be an additional incentive to find the repair language. And it certainly fits within the purview of this committee, and it hasn't been advanced out of this committee as an independent bill where it can get its own up or down vote. So it's either going to happen in the SAFE Act, which again I think is subject to some substantial doubt, or it's going to happen in the Omnibus bill. And this is the Omnibus bill vehicle, and whether we like it or not, Mr. Chairman, if we're not going to pass policy, if we're not going to pass a lot of policy out of this committee as standalone bills, it kind of forces the policy bills into the Omnibus bill. We have no choice but to use this as a vehicle because there aren't any others. So that's the position we're in, Mr. Chairman. I encourage support for this amendment.
And Mr. Chair, I forgot one thing.
Senator Latz, Senator Bingham.
I don't want a law enforcement to be used as an example for a constitutional challenge. I think that would re-victimize a community and certainly not be ideal for a law enforcement professional. So I think we really do need to focus on fixing this. I think having this in the bill, Senator Limmer, will allow for that conversation to have in conference committee. So that I forgot to mention that.
Thank you, Senator Bingham. Any further comment? All right, members, if you would turn your cameras on and your microphone on, we'll take a vote on the A35 amendment. All those in favor of the Bingham A35 amendment indicate by saying aye.
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 Those opposed indicate by saying no.
No.
No. Motion fails. We are back to Senate File 970. With that as amended, with that, members, we will be in recess then until 5:30 this evening. Please use the same link when you log on this evening, and we will see you there. The committee is now in recess.